Okay. Thank you everyone for attending. Judge Bayo is unable to join us at this time, so she asked that we kick off the meeting without her, and she will join when she can. We are streaming, so I'm just gonna do a quick attendance in no particular order, just based on the people, how you're appearing in the chat box. So my apologies, but Judge Abrams present, Judge Roraback, Judge Spader,
Present.
Attorney Generis,
Present.
Attorney Pocklington,
Present.
Attorney Gentis,
Present.
Attorney Sternberg,
Present.
Attorney Salato.
Present.
Did I slaughter your name?
Oh, that was perfect.
Good. Okay. Thank you. Attorney Schmidt, also here. As the email stated, you'll notice that we're shorter a member this afternoon. Judge Morgan stepped back from this committee, and we thanked her for her dedicated service to this committee for several years. But this is the full membership minus Judge Bayo at this point in time. So we will officially call the meeting to order. And I hope you all had an opportunity to view the draft minutes from September 26th. Does anyone have any issues or amendments they'd like to propose?
I'd only ask that Attorney Pocklington be, I believe he has 2 middle initials. And I believe it's AR.
Ouch. You're not wrong, but ouch. I don't know where you're going, Jeff, but ouch.
I just want to make sure it reflects with due respect to Attorney Pocklington.
Absolutely. Are we okay, Attorney Pocklington, on how you're listed on the page? Am I missing the joke here?
Yeah, I think so, but I think I'm missing it too, which is why I'm trying not to. Anyway.
I'm just pulling up the page to make sure we made some updates, because Attorney Gentis, you were listed twice.
I didn't see that.
Let me just see how we're listed on the
Yeah, no, he's not wrong. It is James A. Pocklington on here. It's technically James A.R. Pocklington, but I've gotten very used to computers only accepting one middle initial over the years, and I really don't care. We can move on.
I can absolutely have it updated on the website, no problem. External affairs is pretty fancy. They can handle the two. So I'll have it updated so it properly reflects your appointment. And we can amend the minutes, and I'll resubmit them. We want it to be accurate. I agree with Attorney Gentis. It should accurately reflect your appointment. So I'll go ahead and have those recirculated, and we'll leave them in draft status, and we can take care of them the next time then. I don't know that we need to formally make any motions. Do you want to make a formal motion to amend, Attorney Gentis, just for the record?
I can just move for approval as
Sure.
as amended.
Absolutely. Then I have a second.
So seconded.
Okay, perfect.
And I technically have to abstain because I was not present at that meeting.
Thank you, Your Honor. Okay. Moving on to.
Well, but you have to call with a motion.
Oh, I'm sorry. Yes.
I vote in favor.
Thank you. All those in favor?
Aye.
Aye.
Thank you for the reminder, Your Honor. I'm not used to sitting in the seat, so. Old business. Few items for old business. Property calendar notice has been updated statewide. The copy that was sent to you is what's currently available on the Judicial Branch website. So it's not the exact version that counsel and the parties receive when they get it via mail. So there are sometimes some formatting issues on the website view because it's a generic one. We didn't want to circulate one with a specific case header, so just a district header, so that we weren't pulling anyone's foreclosure case and sharing it with the world. But all of those calendar notices are available on the branch's website. Does anyone have any concerns they wanted to address immediately or something that we need to put forth at the next meeting?
I had a couple questions, but I'm not sure if like who the audience is for the questions about the short calendar order itself. But I'm not sure like what are we as a committee providing some sort of commentary or not to Judge Bellis? Is that how it works?
So it's my understanding any formal recommendations that come out of this body would go to Judge Bellis and then to, I believe, Judge Bizzuto before going over to court ops as a formal recommendation. I believe that's the appropriate kind of channel that we're working with right now. So we can certainly discuss and provide feedback where we think that there can be improvements made, and those improvements could then formally be submitted for consideration.
Okay, I'm happy to circulate amongst the committee, put it in writing, make it more like some like how the rules committee functions, and then that way that there's a written piece of paper to, or the email itself will be can accompany our next agenda. That's probably the easiest to do. I'm not looking to put, to require everybody to think on their feet.
Okay, that sounds like a good solution. Anyone feel we need to make formal motions as to that? Just want to make sure we cover all our bases. Okay, moving along then. Foreclosure standing order was also shared with you all. I will mention that there is Attorney Pocklington and I actually had a conversation separate from committee business having to do with the affidavit requirement. That's a holdover. The Federal CARES Act, the federal loss affidavit is a holdover from the old standing order. There is authority in some other places, a couple of the forms, but right now that is with legal for review to make sure there will be no negative consequences if we were to remove it from the standing order. So that's why it remains there. I know that a few of you probably looked at it and said, what the heck is this and why is it still in there?
I believe we had some issues with one or two courts that had marked off our motions for judgment saying we did not have a loss mitigation affidavit when in fact they were cases brought within the last year or so. So it was not actually required. So I know that we've resolved that issue at this point, but obviously changing the standing orders is a bigger process than just simply deleting something.
Right. So I again, just waiting to hear back definitively that there will be no negative, that we won't have removed the basis for the prior requirements if we remove it from the standing order. So I did want to update you all on that, and I'll keep you posted. I hope to have an answer relatively soon. Does anyone else have any concerns they want to address right now, or if they do have concerns, do we want to adopt kind of what Attorney Gentis had proposed earlier with the calendar notice, that we circulate something in writing so we could have a discussion if necessary?
I think that's a fair resolution.
Okay, so we can go ahead and do that. And then quality of life improvement suggestions. I did get a few. So if anybody else has any that they would like to send, please go ahead and send them. And what we are going to do is kind of pare them down to more of a bulleted list of some suggestions that are generalized. And then we will circulate that to the group before the next meeting so we can have a more robust conversation regarding what we think those things are going to be. So before the next meeting, if you have any other suggestions, please get them to me. And like I said, I'll provide a bulleted list and we can go over them at the next meeting. And then the last time we met, we had decided that it would be appropriate at this point in time to meet quarterly. Don't know if you want to start that with like a January going forward schedule, or if you need a little bit more time between meetings, but Judge Bayo had suggested that we set the quarterly meeting, pick a date and a time, if it's going to be the last Thursday or whatnot, whatever works for you, from 3 to 4 every 4 months or 3 months. Don't trust a lawyer to do math. Any issues with that?
I think that's a very good suggestion of time and schedule starting in January.
And I know there were some date and time concerns with what works best for court schedules and for other things. I think that we've done a Wednesday, we've done a Thursday, maybe a Tuesday in there. So
Well, I know for both Judge Bayo and I, you can never tell what it's going to be like out there, on a third. It's sometimes, things like today happen where, she just gets stuck, or last time we had a meeting where I just got stuck in the middle of a trial. So it happens, and it happens to, the attorneys as well. You're in a hearing and you don't get out of it. So, but at least if we know it's around that time, we have put in our calendars now, it can help us just have it clear in our calendars best as possible.
Line up a calendar. So we're aiming for the end of January. Is better for everyone? Or do you guys prefer the beginning of the month? The beginning of the month is probably a little bit soon with all the holidays and things.
Yeah, early January would probably be more difficult, so I would propose late January.
Okay. So we are looking at see, Wednesdays, Thursdays. Anybody have any pressing dates? Okay, January 25th is a Thursday, 29th is a Monday, 30th Tuesday, 31st is Wednesday, then we're into February. You want to stick with the Thursdays?
If it's no difference to everybody, I have a slight preference for Wednesdays, but I don't want to be a stick in the mud either. So whatever works for people. Okay.
Okay. You want to do the 24th?
All the days are the same. It looks like
they are.
Yeah, that'd be great. Awesome. If we could do Wednesdays, that would be awesome.
Okay. Push out to the very end. You guys want the 31st? Okay. 31st from 3 to 4. Okay.
Sounds good.
Awesome. Thank you, everybody.
Mm-hmm. Puts us back out to April
24th. July 31st and October 30th.
Perfect. Any issues with that schedule? Thank you. Hi. We'll let Judge Bayo know and record that for the minutes. Anyone feel we need motions for our schedules? Happy to do so. Okay. Lastly, any new business that anyone would like to set forth? Judge Warbeck?
Well, now that we've made it through the middle initial decision and the scheduling decision, I did a calendar a couple of weeks ago, and for the first time was confronted with this phenomenon where lenders, foreclosing parties, have a contract with the attorneys where they're paid by the engagement rather than by the hour. And so when I was looking at the reasonable attorney's fees, it was, well, this is what, this is what our client, this is the deal we have with our client. And it's like, that's unusual because there's no breakdown of how you're spending your time. It's just a flat fee. That might be reasonable for your client to pay you, but is it reasonable to visit those costs on the defendant? I don't know if anyone else has confronted that phenomenon and whether maybe this is the brave new world and we should expect more of this going forward. And I'm not even sure this is the appropriate forum in which to be having this conversation, but I didn't want people to think that we're sleeping through the attorney's fees component of the judgments that we enter.
That came through in my role as the old guy in the corner who says what we did years ago. I mean, I think that was an issue years ago with the big firms. And it was like, you know, why get upset about it? Because they're more the defendant is getting charged less than with people who bill hourly. So it was like,
well, that wasn't the case in what I saw last week.
Oh, really? Okay, then it's a whole different.
So yeah, I'm not one to raise a fuss if it's coming in, you know, below $3,500 or something like that. But when it's like $6,000, like, you know, where does that come
per
from?
Engagement? What kind of lender is?
It just
something
was
that the FTC is about to knock on the door at that place.
Well, you know, it is. It does get my attention when fees vary so widely for what appear to be very similar cases, and the bigger firms tend to be those that are most reliably reasonable in my experience, and some of the firms that do less of this, I think, are testing the court's interpretation of the word reasonableness sometimes. But
so I agree with Judge Abrams. This is like a Fannie Mae and Freddie Mac rules that flow down from sort of extreme control of third-party expenses. And I think at one point it was like maybe 15 years ago, it was about $1,750 was the approved fee that someone had to take in order to take a case to judgment, which was absurd. It's absurdly low. And then, you know, now it's moved up since, but yeah, when it's consistent with the general amount, we don't as just, you know, speaking as one borrower's lawyer, we don't have an issue with it. It tends to be, occasionally you'll see like a solo who's made a federal case out of a matter or something else. But yeah, no, we appreciate the scrutiny, but in terms of the low blocks, we have no issue with those. And it's typically, George and James can correct me if I'm wrong, but it's typically, here's your baseline plus like fees for mediation, those kinds of things. Those are always fine.
Yeah, our typical, the way we process, there's 3 types of billing in at least from the big firm perspective. It's the general milestone, which is from referral through to completion of the case, is a set dollar amount. Often, as Jeff mentioned, Fannie and Freddie have their rates. That's very sort of trickle down through the industry. George, I think you guys do the same thing, but just obviously there's no like collusion or anything. But the way we do it then is that there are certain things that are done on a per event basis. For example, a motion to substitute, which is an additional item outside the routine, has a nominal dollar amount. A mediation session, regardless of whether it's a half hour of going over loan documents or 2 hours going over payment histories in excruciating detail, are usually billed at the same amount. The only time my office bills hourly is if there's actual litigation like motions for summary judgment, responses to motions to dismiss, etc. And that's pursuant to just sort of industry standards in that regard. But ultimately, sort of to go back to what Judge Abrams said earlier, this is one of those things that's sort of cyclical in the industry, almost tidal. Every 5 or so years, we get more attention to the attorney's fees, whether the flat fee arrangement, the milestone billing, is appropriate or not. And I always find myself coming back to, and I think Judge Spader's the only one that could go physically take a look at that. In the law library in the New Haven Superior Court, there's actually one of the really nice sort of old-timey historical documents that's been kept, was something that the New Haven Bar did in the late 1800s, memorializing agreements among attorneys about how much to charge for certain activity. And so the idea of milestone and sort of flat fee billing, it's not new, but I would suggest that if you see someone that's not one of the more active firms in this particular industry go in that route, that they may be not necessarily following the industry accepted numbers that are like what Judge Abrams and what Jeff were saying are sort of liked by everyone because they keep it low and reasonable.
And I'm not looking to make a federal case, and I've learned something here. I didn't even know that Fannie Mae and Freddie Mac had kind of approved. I guess we're back to the filed rate doctrine. It's like if it's good enough for them, it should be good enough for the rest of us. Far be it from me to tangle with the supremacy clause.
Yeah, I would agree with what James said. For the most part, if you look at 10 cases on calendar from our office, the attorney's fees will be within $100 of each other on every single one. Freddie, Fannie, standard amounts. Everything else is kind of based off of those standards. The only times we run into larger amounts are when we have years and years of litigation on a file, and the fees might get up to $10,000, $12,000 or something like that. But for the most part, everything is around the same amount. And it's actually interesting. Many times we'll have cases on calendar and the attorney's fees and the condo foreclosures end up being higher than our attorney's fees, and 5 times as much work went into our cases. So I haven't had an issue recently with that, but I haven't seen any attorneys requesting numbers that high for attorney's fees in standard foreclosures with nothing out of the ordinary. So I definitely will keep an eye out for that. For the most part, I know our office, McCalla, many of the other larger firms that have many cases on calendar will have fees right around the same amount, and it's pretty standard. I know at least our attorney fees affidavits break down the actual work that is done in a case, but then we'll also state that it's based on a flat fee agreement with our client per the milestones that are reached in every case. So that is something that does come up every once in a while. Usually it's with a judge who may be new to the foreclosure calendar and doesn't really know what these fees are based on, is used to seeing attorney fee affidavits based on exact hourly amounts, but it's pretty standard at this point.
Thank you.
Thank you. Any other new business anyone would like to raise?
Well, just following up from the minutes, even though I wasn't at the last meeting, has there been has been looked at whether there's something on the judge's computer system to flag those bankruptcy files? I mean, has there been anything looked into on that issue?
I don't believe that at this point there is anything currently in Edison that allows for that. Was a formal recommendation of this committee to investigate it, and Judge Bayo is sending that recommendation through the appropriate channels. So hopefully I will have a report back on where that goes at the next meeting. Anything else? Okay.
Motion to adjourn.
Second.
And this meeting is
Good job,
adjourned.
Becky.
Thank you. Did I turn, sheet white on you all? Because that's how I felt. But
No.
thank you all for your assistance.
You have a
with this
halo,
meeting.
Yeah, I don't know if you can see, but you look very, yes. No one would have taken you on. But anyway.
I appreciate all of your assistance, and we'll forward all of the next draft meeting minutes and everything, and we'll see you all in January. Have a happy holiday, everyone.
Thank you.
Everybody.
Same to everybody.